Welcome, space cadets, to a cosmic legal battleground where the stakes are higher than a geostationary orbit, and the absurdity is, well, let's just say it's out of this world. We're diving headfirst into the wild west of space law, a frontier so new, the legal precedents are still forming, often in the most hilariously unexpected ways. Prepare for a journey through lawsuits over lunar land ownership, the complexities of asteroid mining rights, and the surprisingly tricky legal implications of sending robots to other planets. First, let's talk about something seemingly straightforward. Who owns the moon? You might think this is settled, but the reality is a tangled web of international treaties, vague claims, and a whole lot of, well, we got their first arguments. The Outer Space Treaty of 1967, a cornerstone of international space law, prohibits national appropriation of celestial bodies. Sounds simple, right? Wrong. Interpreting appropriation has proven to be a legal minefield. Does it mean planting a flag? Does it mean setting up a research base? What about mining resources? These are questions that have kept international lawyers busy for decades, and the answers, frankly, are still blurry. Imagine the legal battles if someone starts commercially exploiting lunar helium-3, a potential fusion fuel. The courtroom drama alone would be worth the price of admission, or maybe the price of a lunar launch. Then there's the issue of asteroid mining. Picture this: a company successfully extracts precious metals from an asteroid, bringing back trillions of dollars worth of resources. Sounds like a dream, right? But what about the legal implications? Who owns the asteroid in the first place? Can a company claim ownership of a celestial body? And what about the environmental impact? The legal framework for asteroid mining is still in its infancy, leaving a vast expanse of legal gray area ripe for exploration and potential litigation. We're talking about a potential gold rush in the cosmos, but one where the claim jumpers might not be cowboys, but rather sharp-suited lawyers armed with reams of paperwork and international treaties. One can only imagine the headlines. Asteroid mining company faces billion-dollar lawsuit over space junk, or perhaps, judge rules asteroid belongs to Canada. You'll spit out your coffee when you hear that last one. Let's not forget the complexities of space debris. Thousands of defunct satellites, spent rocket stages, and other pieces of space junk orbit our planet, posing a significant threat to operational spacecraft. Who is responsible for cleaning up this cosmic mess? Who pays for the damage caused by a collision with a piece of space junk? The legal framework for addressing space debris is still developing, and the potential for international disputes is immense. Imagine the legal wrangling if a piece of debris, say, a lost Russian satellite, collides with a privately owned communications satellite, causing billions of dollars in damage. The resulting lawsuit would make the biggest corporate battles on Earth seem like a playground squabble. I wonder what planet the judge was on when they delivered that verdict. And then there's the question of liability in case of accidents. What happens if a Mars mission goes wrong and something catastrophic occurs? Who is liable? The space agency? The private company involved? The individual astronauts themselves? The legal landscape for space exploration is still largely uncharted territory, and the potential for liability issues is enormous. Imagine the headlines: Astronaut sues NASA for negligence after Martian meteorite strike. Or perhaps, space tourism company faces class action lawsuit after lunar excursion goes wrong. The sheer scale of potential liability in space exploration is staggering, making it a legal minefield even more treacherous than the asteroid belt. Moreover, the issue of jurisdiction is a significant legal challenge in space exploration. If a crime is committed on the Moon or Mars, which nation's laws apply? Do we need an international space court? The creation of an effective legal framework for governing human activity beyond Earth is a massive undertaking, requiring international cooperation and a willingness to navigate unprecedented legal complexities. Imagine the scene: a trial on Mars with a Martian landscape as a backdrop, and lawyers arguing over interplanetary jurisdiction. It sounds like a science fiction movie, but the reality is that these questions need to be addressed now, before we establish permanent settlements on other celestial bodies. Furthermore, consider the legal implications of discovering extraterrestrial life. What rights would such life forms have? How would we interact with them ethically and legally? These questions touch upon fundamental philosophical and legal issues that we are not yet equipped to answer. This isn't just about treaties and lawsuits. It's about defining our place in the universe and establishing a legal framework that respects all forms of life, both terrestrial and extraterrestrial. The potential legal fallout from such a discovery could redefine our understanding of law and ethics. It would be a legal event of such magnitude that it would make the discovery itself seem almost secondary. Beyond the grand-scale issues, there are the more mundane, yet still significant legal challenges. Intellectual property rights in space, the regulation of space tourism, and the environmental protection of celestial bodies are all areas that require careful legal consideration. Imagine the legal battle over the ownership of a scientific discovery made on Mars, or the environmental impact assessment for a lunar mining operation. These are all areas where clear and robust legal frameworks are essential to ensure the sustainable and responsible development of space. The legal landscape of space exploration is a constantly evolving and complex one, requiring international cooperation and a commitment to finding solutions to these unprecedented challenges. The legal challenges of space exploration are not just theoretical exercises. They are real-world problems that require immediate attention. The rapid advancement of space technology is outpacing the development of a comprehensive legal framework, creating a potential for conflict and uncertainty. The failure to establish a robust and effective legal system for space exploration could lead to a chaotic and unsustainable future for humanity's expansion beyond Earth. This isn't just about lawyers and paperwork. It's about ensuring the future of space exploration is safe, ethical, and sustainable. It's about ensuring the cosmos doesn't become a cosmic Wild West where the only rule is might makes right. The future of space exploration hinges on our ability to navigate this legal minefield, to create a framework that balances the pursuit of knowledge and progress with the need for responsible governance and international cooperation. The journey ahead will be challenging, but the potential rewards are immense. And as we embark on this grand adventure, let's not forget the importance of a strong legal foundation, one that is both robust and, dare I say, slightly humorous in its attempts to grapple with the truly out-of-this-world challenges that lie ahead. So buckle up, space lawyers, because the final frontier is waiting and the legal battles are just beginning. And remember, folks, even in the vast expanse of space, there's always a lawyer waiting to pounce. The universe, it seems, has a sense of humor, a very, very dry sense of humor.